Investor-state dispute systems, also known as ISDS, are contained in many EU free trade agreements. They raised many concerns. Some say that these mechanisms are about secret court systems designed to allow multinational corporations to limit any progressive legislation approved by democratically elected institutions, while some say that they perform useful function attracting investment and securing property rights. Concerns raised by the ISDS have become even more topical after the ACMEA judgment, where the CJEU found that investment treaties between member states were potentially incompatible with EU law. So after ACMEA, it remained to be seen the court's approach to investment treaties with non-EU countries. Bearing in mind above, it is interesting to recall the CETA saga. CETA is the acronym of the free trade agreement between the EU and Canada. And in September 2017, Belgium requested the opinion of the Court of Justice of the European Union on the compatibility with the EU law of the investment court system provided for by the CETA. Three are the key points: the autonomy of the EU legal order, the equal treatment and effectiveness, and the right of access to an independent tribunal. In January 2019, Advocate General Bott concluded that this mechanism is in line with the EU treaties and the Charter of Fundamental Rights. In April, in its opinion, the court followed the Advocate General, but an adverse conclusion would have had serious political consequences, as it would have implied the need to amend the text of the CETA according to Article 218, paragraph 11 of the TFEU. So after confirming the admissibility of the request, the CJEU analyzed the above-mentioned points. As for the autonomy of the EU legal order, the court underlined that if the European Union binds itself by means of international treaties entailing international obligations, the autonomy of the EU legal order cannot be undermined. In particular, the court must be guaranteed the power to interpret EU law so to ensure its effective and uniform application in all the member states. Now, the envisaged ISDS mechanism stands outside the EU judicial system, but this does not necessarily mean that this system adversely affects the autonomy of the EU legal order. However, two major limits apply to the CETA body's powers. The first major limit on the ISDS mechanism in this case is that it cannot interpret or apply EU law other than the provision of the CETA itself, having regard to the rules and principles of international law applicable between the parties. And the second major limit for the ISDS mechanism, according to the court's opinion, is that it cannot impact EU law indirectly by issuing awards that could have the effect of preventing the EU institutions from operating in accordance with the EU constitutional framework. As for the equal treatment, the difference in treatment arises from the fact that it would be impossible for enterprises and natural persons of member states that invest within the Union and that are subject to the EU law to challenge EU measures before the tribunals envisaged by the CETA. Whereas Canadian enterprises and natural persons that invest within the same commercial or industrial sector of the EU internal market would be able to challenge those measures before those tribunals. And here the issue was whether the CETA had to be compatible with Article 21, paragraph 2 and Article 20 of the Charter of Fundamental Rights. Article 21, paragraph 2 is about non-discrimination on grounds of nationality. But the court simply stated that in this case, that norm would not apply. While Article 20 of the Charter of Fundamental Rights concerning equality before the law applies. While Article 20 does not oblige the European Union to treat all non-EU countries the same, it could apply if, within the EU, there is a difference of treatment of non-EU citizens on the one hand and EU citizens on the other. As for the effectiveness, well, the principle of effectiveness was not breached according to the court because the CETA acknowledges that the parties may take appropriate measures to prescribe anti-competitive behaviors and guarantees their right to regulate in order to achieve legitimate objectives in the public interest. Last, the right of access to an independent tribunal. In the court's view, the CETA bodies are very similar to courts, and they are bound by similar principles of independence. In particular, the issue of accessibility for small and medium-sized businesses could be duly addressed by the Commission and the Council, as indicated in a joint commitment that the Court of Justice of the European Union recalled. And the issue of the independence of CETA bodies would be prevented thanks to some sufficient procedural guarantees offered by the CETA, in particular as regards the tribunal members' remuneration, or their appointment and removal, and the rules of ethics that those members have to follow.